We will start our workshop now with the first topic, Introduction to IP Mediation, where you will have a chance to learn more about the basic concept of IP mediations, the difference between mediations with other ADR techniques, as well as its advantages and limitations. We will have a Q&A session right after this first topic, so you can share with us any question you might have during or right after the presentation. For this first topic, I would like to invite Ms. Alexandra Crawcour, legal assistant and accredited mediators, and Ms. Natalia Kapetanaki, IP administrator and accredited mediators from the Court of Appeals from EUIPO to help us with the first topic. Ms. Alexandra Crawcour is currently the legal assistant and accredited mediators of the Board of Appeals in EUIPO. As a legal assistant since 2010, Ms. Alexandra Crawcour is responsible for drafting decisions on abuse regarding EU trademarks and designs and representing EUIPO as agent before the EU General Court in Luxembourg. Ms. Alexandra Crawcour has been appointed co-mediator in several cases at EUIPO since 2012. She has also engaged in continuing mediation training, mediations, internal workshop, and IP mediation conferences. Our second speaker is Dr. Natalia Kapetanaki has been IP administrator in the Board of Appeals at EUIPO and an accredited mediator since 2021. Previously, she was IP and legal officers for the IMI joint undertaking of the EU Commission and EFBIA. She was also a lawyer, Brussels and Thessaloniki bar qualifications, and lectures of courses on IP and international business law and ADR at Université Libre of Brussels and ICHEC Brussels Business School. Ms. Alexandra Crawcour and Dr. Natalia Kapetanaki, thank you very much for joining us today. Now I would like to invite Dr. Natalia to start the presentation. Natalia, the floor is yours now.
Hello, good morning. Thank you very much for the invitation. It's a pleasure to be here with you and to participate in this seminar. So I will start today's session with an introduction to IP mediation, which will cover the following points. So the different ADR techniques and also the differences that these ADR techniques have compared to mediation, the advantages and the limitations of mediation in intellectual property issues. And we will also try to explore the criteria to identify situations and cases that favor mediation in IP issues, and also refer to examples applied in order to spot this type of cases. So after the analysis of these 3 points, we'll have our question and answer session where you will be able to ask your questions and also discuss on several points that you would like to raise. So the different ADR, I will start with the point of the different ADR techniques and their differences with mediation. The alternative dispute resolution techniques, which are most commonly used, can be listed in the following. So we have, of course, mediation, we have arbitration, expert determination, early neutral evaluation, the technique of conciliation, and of course the traditional way of negotiations between the parties. These are the most commonly used alternative dispute resolution techniques that can be used in order to avoid going through the traditional court proceedings. It is important to mention that, as already explained in the introduction, in the introductory remarks, some of these services. They are already offered by the Boards of Appeal of the EUIPO since 2011. For example, mediation and conciliation, but also most recently, the technique of expert determination. With regards to mediation, this is a process, what we call facilitative process, which means that it's a process led by a neutral third party to the dispute, which is called, of course, the mediator. During this process, the parties to the dispute, guided by this person, the mediator, try to reach an amicable settlement of their differences. The mediator and the parties will attempt to identify what we call common ground and also discover their and discuss on their business interests that may be explored in order to achieve a settlement to the dispute. We will come back to this notion of exploration of common ground and business interest in more detail further on in our session. So let us go through then the other types of ADR in order to explain what they are about exactly, and also to spot the differences these ADR techniques present compared to mediation. On the one hand, we have the arbitration. Arbitration is a very, it's a well-known process, widely used, whereby a dispute is submitted by agreement of the parties to one or more arbitrators who make a binding decision on the dispute. Of course, it's the parties that appoint the arbitrator on a consensual manner. The arbitral awards are enforced by national courts under the New York Convention. It is important to say that all EU member states are signatories of the convention, and therefore the convention is applicable, and the arbitral awards enforced throughout the European Union. We also have the ADR of expert, the alternative dispute resolution technique of expert determination. This is also a technique together with mediation that is offered by the Boards of Appeal of the EUIPO. So it is a process in which an expert is appointed by the parties and gives a binding opinion on the matters that have been submitted for determination. We need to stress that in some frameworks, as for example, in the EUIPO framework of services of expert determination that are offered here in EUIPO, the opinion of the expert may not be binding, and this depends on the parties if they would like to have a binding opinion or a non-binding opinion. The parties should decide when the expert determination starts whether the opinion that they ask for before the expert will be binding or not binding. But in the traditional sense, we could say that the expert determination is binding, but we can also find this type of nuances in different regulatory frameworks. So the parties concretely submit a specific request of a technical, financial or legal nature that is part of the overall dispute. And this specific question, they submit it before the expert. And because there is this specific question is an obstacle to the parties to a viable settlement. So they are unable to agree on this specific technical or legal or financial issue, and they ask this specific question to the expert. So it's the expert is the one deciding on the issue via his determination, and that way, once the determination is drafted and given to the parties can move forward with the rest of their negotiations. So These two ADR, the arbitration and the expert determination, present differences with mediation. So the main difference with mediation is that the binding, but also in the case of non-binding, in the case of non-binding expert determination, outcome of this ADR is decided by the neutral party, the third party, so the arbitrator or the expert. And it's not decided by the parties, the outcome of the settlement, and which is, of course, the case in mediation. And this is a main difference between these two ADR techniques and the technique of mediation. Another commonly used ADR is the early neutral evaluation. The early neutral evaluation is a process, voluntary and confidential process, in which the parties to a dispute request an independent opinion on the merits of the case to an evaluator. Early assessment of the legal position and the arguments of the parties is the main content of this early neutral evaluation. Having this opinion of the evaluator can help the parties have a more realistic assessment of the potential outcome of the case, and also it helps them avoid further unnecessary stages in litigation, but also further legal costs. Again, the difference of the early neutral evaluation compared to mediation is that the assessment of the case, the evaluation of the case, is made by the evaluator, and therefore the outcome of the evaluation is not decided by the parties, which is, of course, as we already mentioned, the case in mediation. Conciliation, which is also a technique offered by the EUIPO boards of appeal, as we said, is also a facilitative process. This is a process like a mediation, which is in which a conciliator suggests possible solutions for the dispute to the parties in order to reach an amicable settlement of the differences. These proposals that come from the conciliator, they are discussed, negotiated, and fine-tuned by the parties. So the common elements here from the conciliation and the mediation is that they are both facilitative, as we mentioned, processes, which means that it's the parties that are the decision makers and not the third neutral party. The conciliator and the mediator do not make a decision. The difference, however, between the conciliation and the mediation is that in conciliation, the conciliator suggests solutions to the parties. Of course, it's the parties that they decide to adopt this solution, so they decide the outcome. But there is concrete suggestions of solutions to the parties in conciliation. This is not the case in mediation. In mediation, the mediator, as we will see also in more detail in the second session of today's seminar, plays mostly the role of a process manager towards a possible settlement without concretely suggesting solution to the parties. Lastly, we have the traditional notion of negotiation. So this is considered as, of course, the discussions which take place between the parties and their legal counsels without involvement of a third neutral party. So there is no third party that would guide the process or suggest solution, such as the case of mediation and conciliation. So, of course, the difference here compared to the other ADR techniques is exactly this absence of a third neutral party that participates in the discussions. We also need to mention that there is a possibility of combining different ADR processes to adjust the process to the needs of a particular dispute. So it's up to the parties to decide whether they would like to use one of the combinations of ADR. There are possible combinations that could be agreed or between the parties. For instance, with the introduction of a relevant clause in the contract between the parties, and of course, from which the parties may benefit. So we could have, for example, combination of mediation with arbitration, which means concretely that if mediation fails, so the parties start with mediation, and if mediation fails, the parties can move on to arbitration. We could have the opposite. So we could have arbitration mediation. So the parties can start with arbitration. So after the arbitration pleadings have been exchanged, the parties may try mediation. The advantage of this combination is that the parties already know the case. They know the arguments of the other party very well. And this is very helpful in order, since of course the arbitration pleadings have been exchanged between the parties. So this helps a lot to find a common solution. So after the arbitration pleadings, the process of arbitration stops for the moment, and mediation is tried. And if, of course, mediation doesn't work, the parties go back to arbitration. We could also have a clause that establishes, first of all, the obligation to have negotiation. Then, if negotiations between the parties and their lawyers do not work, then we go to mediation. And again, if mediation fails, we go to the parties advance to arbitration. And also, of course, we can combine mediation with other types of ADR other than arbitration. We can combine mediation with expert determination. For example, we have discussions on mediation discussion ongoing, and then we have a particular technical issue that comes up, and the parties would like to have the opinion of an expert on this technical issue. So in that case, the mediation stops for a certain time, and then the parties consult an expert in order to have their answer to this particular technical question. And as soon as they have the answer, mediation resumes. So that brings me to the end of this first point. Thank you very much for your attention. And let me now give the floor to my colleague, Alexandra.
So now that Natalia has explained to you the different ADR techniques, let me focus on mediation, which is my area of specialization in ADR. Okay? Before we start, I would like to get to know you better. And for this, I would kindly ask you to answer a question with the yes or no button that our technicians will now enable for you. It's an easy question, and it is, have you ever been involved in a mediation as a party, as a lawyer, or as a mediator? Have you ever in your life, it doesn't matter if it is an IP mediation, or maybe it was a mediation on a family affair, or on something regarding a business of yours. Don't be shy. There is no good or bad answer, and I am not going to ask you about it. This is totally confidential. As you will see, the word confidential is very important for us. So don't worry. We have we have 85 participants with us today. So I hope to see the results in brief. In the meantime, let me tell you something about myself. Since I'm asking you something, I'm going to tell you something about myself as well. I used to work for many years in a law firm. And what I most liked of working in a law firm was the daily contact with clients. So then when I started working at EUIPO, and I mostly draft decisions in appeals and second instance matters, I really missed the contact with clients. So I was so happy when in 2012, the mediation service started at EUIPO, and I immediately enrolled. because I saw so many advantages for our users. Natalia has already explained to you that mediation is a process whereby two or more parties to a dispute attempt by themselves and on a voluntary basis to reach an agreement on the settlement of their dispute with the assistance of the mediator. So we have now the results of the poll. Thank you for participating. And I can see that from the participants, 30% have actually already participated in the mediation. So for them, I will be saying things that they already know. And 70% have never participated in a mediation. So I hope to be very clear and that you understand what the principles of mediation are, what the advantages are, and concretely for the field of IP. At the end of this session, we will be open for questions and obviously along the way of this seminar as well. So thank you very much for the poll. We're going to take this out. So let's look into some of the advantages of mediation in IP in detail. So the first advantage I would like to mention is that with mediation, it is possible to focus on commercial interests and on business solutions. Of course, during a mediation, importance must be given to legal issues, but primarily we focus on the commercial interests and look for the business solutions for the parties. This is a very important difference between mediation and other traditional proceedings, as well as other alternative dispute resolution tools we were seeing before. Here, the core issue are the parties and their business interests. The objective is to reconcile both parties' interests and to find a solution. If the conflict is resolved before a court, the court will not take into account personal or business issues or interests. A judge will mostly rule over the facts presented and on the basis of the regulations and the case law. With a mediation, it is possible to obtain a global solution on parallel or complex IP disputes. What do I mean with this? You know, in general, with mediation, it is possible to solve several parallel disputes which are ongoing between the parties. All of you are IP experts, so you know that IP is a very complex field that can involve different rights. Indeed, it is frequently the case that the same parties fight over concurrent rights, such as trademarks, patents, copyrights. All these issues can be solved in one single mediation process. A mediation can also avoid the risk of divergent decisions in different jurisdictions. So as it often happens, that the same parties may be involved in conflicts in different jurisdictions at different levels. For instance, at the EU before us, in the US, or in one of your countries. Imagine, for instance, two parties with global business interests. They have a conflict regarding the same trademarks in different countries, for instance, in Vietnam and in the United States. A likelihood of confusion may be found in Vietnam, and no confusion may be found in the United States because obviously the parameters of deciding are different. And this happens often, and it is a problem for both parties, as it is not a satisfactory solution for either of their business interests. And it also must be taken into account that it is sometimes very difficult to enforce a judgment in several countries. However, agreements resulting from mediations are usually much more likely to be complied with by the parties because it's themselves who have drafted it. Mediating a multinational conflict and finding a solution can therefore avoid obtaining different decisions from IP offices and divergent judgments from courts, which would not assist to resolve the actual conflict between the parties, but would only prolong it. Mediation also supports the enforcement of the agreement, so overall, it is certainly in the interest of the parties in this situation to find a settlement, including all these conflicts. Now, this leads me to the next advantage of mediation, which is cost and time savings. Obviously, if the parties are involved in administrative or court proceedings, this costs money. It may be in the form of lawyers' fees, court fees, and many more direct costs that are implicit to litigation, such as providing evidence, surveys, declarations, you name it. An effective settlement of a dispute by means of a mediation will considerably reduce these costs, especially when the conflict involves different rights and different jurisdictions, as we've just seen. As to time savings, you know that courts around the world, they're not always very fast in taking decisions. Also, with the possibility of endless appeals before different instances, an IP conflict may be protracted in time for years. For example, concerning European trademarks, I am aware of proceedings that started here in EUIPO in the 1990s and did not end until recently. Think of the famous baby dry trademark. It was filed in 1996 and took nearly 24 years to resolve. If a matter is taken to mediation, it can be settled within a day or within a couple of weeks, but it will never take so many years. So the former has a direct connection to the next advantage, which is flexibility. Mediation is a very flexible process. It is basically in the hands of the parties. With the help of the mediators and, of course, their lawyers, they can decide together how to solve a complex matter and what aspects, rights, and territories they want to have included. The process is tailored to the needs of the parties, as it can, as mentioned before, focus on their business interests and include other rights. We will also see this flexibility when we talk about the mediation process tomorrow. And finally, confidentiality. This is one of the most important aspects of mediation, as it concerns all the parties involved, including the mediator. Contrary to the decisions of IP offices and of court judgments, which are of public domain, mediations are not disclosed to the public, unless the parties want, of course. It is very important for companies that no failures or negative news about them appears in the press or in social media. It can happen, for example, that a company with whom another company has a conflict discredits it in public. Or simply, if a company loses a court proceeding and this appears in the press, it can be negative news for the company. Indeed, I recall a large company in France who sued an individual, a person in Italy, for trademark infringement. This Italian person published it on social media and showed the large French company as abusive. This alone was sufficient for the French company to go down in the stock market. If the parties, however, decide to go to mediation, it all remains confidential. Neither the parties nor the mediators may disclose any information received during the mediation, unless there is a clear agreement to do so, perhaps in the form of a joint statement, once the conflict is settled. This is why generally a confidentiality agreement is signed by all actors in the mediation before the mediation begins. This confidentiality is twofold. The mediators cannot disclose what the parties tell them in private during mediation to the other party, unless they expressly authorize the mediator to do so. And none of the parties, none of the lawyers or the mediators may disclose the contents of what is discussed in the mediation to the outside world. So now I have only mentioned advantages, and I'm sure there are many others that you can also think of. However, there are also some limitations to IP mediation. The first I would like to mention is that IP mediation is not available in ex parte proceedings. What does this mean? This means that there has to always be, at least there have to be two parties to the conflict. Mediation cannot take place when only one party has a conflict with the IP office. For example, if a trademark is not accepted because it was considered as devoid of distinctive character, this is a matter of public interest. It cannot be negotiated. Likewise, if a trademark or another IP right cannot be registered because of reasons of public policy or morality, this can hardly be solved by mediation. Further, mediations are generally not suitable for solving counterfeiting or piracy cases. When a conflict involves criminal law and one of the parties seeks sanctions, these situations can hardly be negotiated. I would also like to mention that there might be abuse of the ADR process. Now, this is actually not a limitation, but it is something we need to be aware of and we need to avoid. It may happen that parties engage in a mediation process not with the intention to find an amicable settlement, but to delay the administrative or court proceedings in their interest. For instance, as you will see in our tomorrow's presentation concerning the mediation process before the EUIPO, mediation suspends the appeal proceedings. So we need to avoid this, that it is used unduly, obviously. Finally, it is possible that some cases are excluded from mediation on the grounds of legal provisions of the national law. So it's important to look into that as well. But let's go back to advantages in the mediation. Let's go to the criteria to identify situations favoring mediation in IP. So when is it appropriate to suggest mediation in the face of an IP conflict? So if we have a look at the nature of the case, it may be that there are identical or similar proceedings in other countries involving the same parties. As we already said, these multinational conflicts between the same parties can be solved in one mediation in much shorter time. It was also mentioned before that IP mediation may be appropriate to resolve conflicts involving different IP rights. The parting point with us at EUIPO is always a trademark or a design, but these rights may be linked to another IP right, as for instance, a patent. When there have been long-standing relations or conflicts between the parties, it is also a good scenario to initiate mediation. Sometimes it emerges from the submissions of the parties in an appeal, opposition, cancellation proceeding that they have previously been involved in a business relationship, perhaps a license agreement, or that one party was the agent or representative of the other party. There may even be family relations between the parties. In these cases seem to be especially suitable for mediation as they already know each other. Also, when the parties have tried to negotiate in the past, but without success, it is possible that the mediator can assist where perhaps the lawyers have tried, but did not succeed. This is because the lawyers defend the interest of the clients and they're very good at it, but the mediator is a neutral facilitator. He remains or she remains impartial and is a neutral facilitator who can challenge the parties to an extent that maybe a lawyer cannot. It also may be in an IP dispute that both parties have strong and weak legal points. More than often, a case is not clear-cut. Each party may succeed on one point and fail on the other. For instance, in a trademark dispute, one party may successfully oppose a trademark with respect to some of the goods and services, but have the opposition rejected with respect to the other goods and services. It may also be that one party has a strong position in one country, but that the other party would most probably win in another country in the same trademark conflict. This is a legal uncertainty that makes mediation a very helpful tool to effectively solve the dispute in these cases. This leads me to another aspect, which is the positive, for which mediation may be positive. It is when it appears that parties could cooperate at a business level. They haven't cooperated before, but maybe due to their area of expertise, we can see that they could actually do business together. And this is especially when the parties have the same commercial interests. An exploration into a settlement which contemplates a future cooperation would lead to a highly satisfactory outcome, which for some reason has not been previously approached by the parties or their lawyers. It might also be because of linguistic reasons, or simply because they never thought it, that they didn't speak about it before. Finally, an IP conflict also appears suitable for mediation when the parties' business activities are in different commercial areas. I remember a trademark conflict of two similar trademarks, when it appeared clearly from the file that although the applicant had requested to register the trademark for many goods and services in many different classes, it was only interested in a very specific business. In this case, it was paints for industrial purposes. The other party, the opponent, had a similar trademark. However, it was specialized in cosmetics sold to the general public. Of course, both companies were interested in colors and in paints, but they were not the same colors and paints. They were of completely different nature. So they would never collide or be competitors on the market. And this matter was solved in a very quick one-day mediation. There are many more situations that can emerge during the mediation process. For instance, it can also turn out that one party has interest in one territory and in the other, etc. In that case, if this would be to take place in Europe, that involved a European trademark, it cannot be solved in an administrative proceeding before the EUIPO that the territory is parted due to the unitary character of the European trademark. However, the parties may agree on a petition, on a business partition of the territory on the basis of a private agreement found in mediation. As you can see, there are many situations in IP that may be suitable for mediation. And I could continue for a long time, but I think we've reached the time. I hope to have illustrated some of these advantages with sufficient clarity. But I am, of course, available for questions. I think this is the time now. Thank you very much for your attention.
Yes, thank you very much, Alexandra and Natalia, for your very comprehensive presentation on the introduction of IP mediation, the differences with other ADR techniques, as well as the advantages and limitations. And I think the very important, like the criteria to identify the situation suitable for mediations. So now we will go to the Q&A session of the first topic. I would like to invite both Alexandra and Natalia to join us for the Q&A session. And I would like to open the floor for all the participants. You can raise the question directly to Alexandra and Natalia, either by raise your hand and speak out your questions, or you can use the chat box and type your questions. And you can raise the questions in English or in your local language. We have interpreter with us who will help us with all the interpretations. I think while we wait for the questions from the audience, I have received some questions in advance. I would like to ask Alexandra and Natalia. I think the first two questions I would like to ask Alexandra, because I think it relates to your presentation part. Do IP mediators need to be an IP expert as well as business expert? Because you said mediation focuses on commercial interests and on business solutions. So it's the first questions, and the second questions is regarding the abuse of ADR process, as you mentioned in your presentation. How can we recognize this and how to avoid it? Yes.
Okay, well, thank you very much for these two very pertinent questions. So to your first question, does an IP mediator need to be an IP expert? Okay, an IP mediator does not have to be an IP expert. However, I think it is a huge advantage that the mediator knows perfectly what the dispute is about and what has been talking about between the parties. Here at EUIPO, most of our mediators, I think all of our mediators, are very experienced IP lawyers and jurists. And from my own experience, as I say, it is extremely helpful if with only a glance at the file, I understand perfectly well what the problem is. The only thing we have to be very careful with is not to take a decision ourselves on the dispute. Because as mediators, we have to remain completely neutral. So we are never involved in the file as decision taker. Obviously, we do not have any contact because we need to maintain ourselves completely neutral. However, we also have to be aware that we cannot decide the case in our minds either. We have to give both parties the opportunity to explain, and it is in the hands of the parties to find a settlement and not for us to decide on the case. Okay, we're not the judge, we're not an arbitrator. All we do is facilitate the communication between the parties and the negotiation. But it's very much easier for us if we understand what we're talking about or what the parties are talking about. And your second question, how to identify abuse in ADR process, of course it's not easy, but it depends on us as mediators that we keep the flow of the mediation. What does this mean? When mediation is initiated, the mediators take charge of the mediator, contact the parties. I will explain this in very much detail tomorrow. And we start a dialogue, normally via email and telephone, to see how the process will develop. Already there, we will see if a party is delaying the matter. We will give the party deadlines to comply with filing a statement, a summary of the case, a deadline to reply to questions, etc., etc. So the mediator will set the pace. If we see that a party is delaying the matter, we will say, hey, I'm sorry, unless you send us a reply within a certain amount of time, we will conclude this and we will continue with the appeal proceedings. I hope this answers your question.
Yes, thank you very much, Alexandra, for your very clear and detailed answers. Yes, I think we received now quite a few questions from the audience. The next questions is I also to address to both Alexandra and Natalia. You can both try to intervene when you see it fit. When the mediation service set up in EUIPO in 2012, did EUIPO apply any incentive to increase the recourse to mediation?
I don't know what kind of incentive is meant. If what you mean is to facilitate the mediation for the parties, yes, because what we did at EUIPO is that we never asked for any fees for the mediation. So basically, in order to initiate mediation at EUIPO, as you will see in more detail tomorrow, you need to have an appeal pending. To file an appeal, you need to pay an appeal fee. But in this appeal fee, let's say that automatically it is included that the parties may initiate mediation. So I guess this is already a very great incentive to increase the mediation. I don't know if I answered the question of who was asking this.
May I just complement to what just Alexandra mentioned, that indeed there is also, we are working also towards increasing recourse to mediation, and we will see it tomorrow in a more detailed way, but we have a new service, the Alternative Dispute Resolution Service, that was created, which also helps guiding parties that have decided to recourse to ADR, mediation, conciliation, and other services, expert determination, and also plays the role of providing good offices, services to parties and to our, of course, EUIPO mediators, in order to ensure the efficient and productive process and smooth, let's say that the smoothly way of conducting mediations and other ADR before the boards of appeal of the EUIPO. So there was a service specifically created for that, in order to help parties and mediators to organize the whole process and facilitate recourse to mediation.
Thank you very much, Natalia and Alexandra. For tomorrow, we will have a chance to learn more about the history, setup, and operation of the mediation service at EUIPO. So yes, thank you. Next, we have 4 questions from our colleagues at the IP office of Brunei Darussalam. So we also encourage all the colleagues from other ASEAN IP office. If you have any questions, please raise your hand or type your questions in the chat box. So the next, the questions from our colleagues from Pru IPO office. Is the outcome of mediation legally binding? If not, how would it ensure the compliance by the parties? For this, may I invite Natalia to help with the answers.
So of course, as we said, it's the parties that decide the outcome of the mediation, and until the settlement is reached, nothing is binding, meaning that the parties can decide to stop in the middle of the process of the mediation and decide that they do not want to go through with the settlement. However, as soon as a settlement is reached and documented and signed, a settlement agreement, then of course it is binding in the sense of contractual obligation. And in that sense, it's like parties have signed a contract and they should abide to the contract, as they should normally abide to all contracts that they have adhered to. So the outcome of the mediation is legally binding, yes, for the parties, in case only when the settlement agreement has been signed and documented.
Thank you, Natalia. Yes. The next questions. In mediation involving multiple jurisdictions, will the mediation be done by one mediators in one jurisdiction or multiple mediators in the different jurisdictions, arriving at one common agreement? For this, I would like to invite either Alexandra or Natalia, if you could help to answer these questions.
Yeah, I can take this over. Thank you very much. No, the idea is that there is a starting point in one jurisdiction, okay? For instance, the EUIPO. And then it turns out, or the parties obviously already know before, that they also have a problem now with Brexit, for instance, in the UK. So since the mediator is not a decision-making person or entity, and this goes away from EUIPO and everything, it is the parties who make the agreement. One mediation with one mediator can solve a problem, or it's the mediation and it's the parties who solve the problem in several jurisdictions. Of course, it is not excluded that the parties go for another part of the dispute to another mediator. However, if the mediation runs well, they can put everything into the settlement agreement. You have to see the settlement agreement as a big pot where you put all the ingredients you want. Okay, and it is the parties alone, the two parties who are putting the ingredients into the pot and who can finish the stew, and the stew will be theirs to eat. At the end of the day, I don't know if this helps, but obviously it is possible that in only one mediation, a conflict in different jurisdictions is solved. What is important that the lawyers help and will then establish, obviously, the legal parameters to the agreement, which also comes back to the question that was raised before. Is it binding? Of course, the lawyers will establish in what ways it is enforceable and by what law it is ruled. But that is for the lawyers to decide and to figure out.
Yes, thank you, Alexandra. I also, yes, Natalia, please go ahead.
I completely, I mean, this is exactly what the principles, what exactly Alexandra said is the principle of mediation is also to centralize, let's say, all issues that may come from the IP portfolio of two parties, if possible, in a globally in a one process. So this is one of the biggest advantages of mediation. We could, in a sense, the parties could choose, however, co-mediators. We will see that this in the session of in the next session today, and in the sense that, again, as Alexandra said, it will be one process, of course, centralizing the issues to be discussed. But if they feel more comfortable, let's say, because they would like to have, they speak different languages and would like to have one co-mediator that speaks the language of one party and the other co-mediator speaking the language of the other party, this can be also an option. But again, everything should be on the basis of the existence of one centralized process, because this is a major advantage of mediation that helps, let's say, streamline all issues and provides for a general solution for the parties. And this is, of course, for the parties, they gain time, they gain money, avoiding the multiplication of processes in different jurisdictions. There is this possibility of co-mediators if they would like, not in the sense of jurisdiction as the question asked, but in the sense of having, for example, different, for the facilitation of the process, different languages or different skills. We could also have co-mediators that have different skills, but I will not enter into detail because we will discuss it just after the break.
Yes, thank you, Natalia, and thank you, Alexandra.